Our firm represents many clients who are charged with offenses such as domestic assault, criminal harassment, assault, sexual assault. And a very common question that's asked is, if I do some upfront counseling, will that assist at all in getting my charges dropped? Is there any way that upfront counseling will assist? In this particular situation, in very rare circumstances, it might. It has to be a situation where the Crown really perceives they have an inordinately weak case. It really doesn't meet their test. Their test, by the way, is there any reasonable prospect of conviction? So let's take a situation where a domestic assault occurs. The Crown looks at their case. It's just so weak that they want to offer a peace bond, but they want something for that. And one of the things to do in this situation, if we can negotiate, is to do some upfront counseling, convince the Crown you've taken all the steps to rehabilitate yourself. But it has to be a situation where the Crown just doesn't feel they're going to win, though. There's no question about that. So you might then plead guilty to a peace bond, that is a recognizance not to associate or communicate with the victim, and then the charges could get dropped. But I want to caution you, this rarely happens. There are some narrow situations where it could be helpful, though. In another video, I discussed the situation where counseling can help you resolve a case to get the lightest deal possible where you do plead guilty. But again, I caution you, very narrow, but I have had many cases in my career where the Crown felt they had a weak case. We did some upfront counseling and negotiated a peace bond to withdraw the criminal charges.